All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Ronnie. Good morning. Welcome to the Massachusetts Appeals Court. I'm Judge Desmond. To my right is Judge Sachs. To my left is Judge Brennan. We'll be your panel for all 6 cases this morning. I expect that we'll hear 3 cases and then take a break, short break, and then come back and finish the remaining 3 cases. As you may or may not know, I don't know that I recognize too many faces here this morning. 15 minutes per side. We have no rebuttal here at the Massachusetts Appeals Court. I can tell you that we've read your materials, we're familiar with the briefs, we're familiar with the cases, so you need not repeat much of that, but of course, how you use your 15 minutes is up to you. That said, we'll begin with our first case on the docket, 23P1028, Commonwealth versus Michael Collins.
Morning, Your Honors.
O'Meara.
If it pleases the court. My name is Robert O'Meara, representing Michael Collins, the appellant. Your Honors, as argued in my brief, in this case, proper vouching in the Commonwealth's closing arguments greatly prejudiced the defendant to the extent that his conviction should be overturned. In Commonwealth versus Kozak, the court laid out 4 factors that the courts use to analyze claims of error in a closing argument. Those 4 factors are: did the defendant seasonably object to the argument? In this case, yes. Was the prosecutor's argument limited to a collateral issue, or did it go to the heart of the case? In this case, it did go to the heart of the case. Was there any curative instructions? In this case, defense counsel requested a curative instruction, and it wasn't given. In fact, I think counsel had drafted a curative instruction for the court, and the court refused to give it.
Did they present that curative instruction to the court?
I'm sorry, Your Honor.
Did they present that curative instruction to the court?
From the record, it looks like it was presented to the court. Defense counsel started to narrate what that curative instruction was, but it wasn't completely in the record. And the last factor was, did the error possibly make a difference in the jury's conclusions? And the answer to that, I believe, is yes.
I think I understand your argument. Just so I'm clear on it, though, when you say that the comment went to the heart of the case, you're talking about the credibility of the victim here? Or what do you mean by that? So I should just ask.
Yeah,
when you say it went to the heart of the case, how so?
There was testimony. A co-defendant testified, Angie Davis testified, and her testimony was a little confusing. During her testimony, she admitted that she had, during an interview with the police, she admitted that she had taken part in the abuse of her
And I shouldn't have said the victim. I meant that she's purportedly a victim of other things, but you understand who I'm asking about. Sorry, go ahead.
She had pending charges at the time of this trial.
She had pending charges, 7 counts of child abuse. And lost my train of thought. So, as far as the error really concerned, I think, in the jury's mind, it really what it concerned was, the prosecutor's effort to sort of divert the blame away from Angie Davis when she said, she's going to have her own trial. I think that in the minds of the jurors, the conflicting testimony was, well, who was responsible for the injuries to the child? So the prosecutor, by improperly vouching tried to divert the attention away from Angela Davis. So you don't have to worry about Angela Davis. She's going to have her own trial.
Well, let me ask you
But
this.
she didn't.
Let me ask you this. First of all, we're only speculating when we're trying to get into what the juries were thinking. Or
Yes, Your Honor.
Okay. And that said, the prosecutor is allowed to respond to the defense closing, correct? And isn't that kind of the point that the judge made at the sidebar following the
Well, respectfully, you know,
the closings?
respectfully, you know, that's really not the case. I mean, the cases that I found said, you know, you shouldn't fight fire with fire, no matter how.
So you're pushing back on the principle that the Commonwealth is not allowed to respond to the defense's closing argument?
Absolutely, Your Honor.
Okay.
Yeah, and I think there's a couple of cases in my brief that go into that.
I've, of course, seen the expression, you can't fight fire with fire, but does that mean you can't respond to a specific attack on the credibility of a government witness by responding to the point that defense counsel made, or does it mean just because you think the defense counsel is playing dirty doesn't allow the Commonwealth to play dirty on a more general level?
The latter, Your Honor, the latter, yes.
All right. So if that's the case, then this was a specific response to a specific attack on the witness's credibility. How is that impermissible?
Well, so the cases say, it says no matter how impermissible the defendant's closing argument might be, the prosecutor can't fight fire with fire.
Has anybody
They
alleged
can't-
that
I'm sorry, Your Honor.
has anybody alleged that the defendant's closing argument was improper?
I'm sorry, Your Honor.
Has anybody alleged that the defendant's closing argument was improper?
Has anyone, meaning,
Has the Commonwealth alleged that the defendant, you're saying that the
I'm
Commonwealth
sorry,
was
Your Honor.
responding to an improper argument raised by the defendant, and I'm wondering who says that the
yeah, in
defendant's
fact,
argument was improper?
I'm sorry, my hearing isn't like it used to be.
Yeah,
But yes,
close
Your
to
Honor, the judge made it a point to say to defense counsel, hey, wait a minute, you're giving me a curative instruction here. What about your closing argument? Because, she thought that he had crossed the line.
And what did the defense counsel say in response to that?
I think he was, from the record, when you read into the record, I think he was surprised.
What did he say?
I'm not sure exactly what he said, but he, again, as I said initially, he did have a curative instruction prepared. And the judge said, wait a minute, I think you crossed the line.
Did he object when the judge declined to give his curative instruction?
Yes, Your Honor.
He objected? Show me
Yes,
where
Your
that
Honor.
is.
He seasonably objected.
Show me where that is, where he objected after she said, I'm not giving it. I thought
me
he
see
had
if
just
I have
acquiesced.
that.
Show me to that. Point that to me.
I don't have the transcript cite, Your Honor. I apologize. But he did object. I can look it up I have my brief with.
He said, the judge said, so you raised it, and defense counsel says, very well. You raised it very clearly, says the judge, and there was no evidence to support that argument. That's all speculative. And defense counsel says, all right, very well, Your Honor.
Yeah, so I think the main point here is
No objection.
well, he objected to the statement in the Commonwealth's closing argument. He did object.
I understand.
But he didn't object to what the judge said to him after.
That's my question.
Yeah. But I think the important point, as I said, is that, just because defense counsel may have stepped over the line, it doesn't mean that the Commonwealth was able to do so. I think that's an important point. I don't have anything else.
Could you just identify as best you can how you say this prejudiced your client? Where's the indication in the record that your client was prejudiced by this fairly brief and limited statement during a pretty comprehensive closing argument?
Yeah, as I tried to explain, I think, so the jury heard Angie Davis's testimony, and she said, you know, I told the police that I abused my daughter, but I lied to them. And so I think at the end of the trial, I would speculate that the jury said to themselves, well, you know, I'm not sure about the credibility of Angie Davis, but, you know, she might have had some part in this.
Did her testimony at all pertain to the charges where the defendant was found not guilty?
She was found not guilty on the second assault and battery on.
Right.
I'm sorry. He was found not guilty on the first count.
Right. And was that part of this same
He was
witness's
found
testimony?
guilty on the assault and battery of the child.
Right.
And and he was found guilty on assault and battery of Angie Davis.
Right.
Okay. So, and the guilty on the child's count was a lesser included. They dropped the dangerous injury part of that indictment. But I'm sorry, Your Honor, to finish my thought.
Yeah.
So then, you know, so they had testimony that my client caused some of the injuries. There was testimony that Angela Davis said to the police, I caused some of the injuries. So I think the impact her closing argument, the improper vouching had, was it said to the jury that, listen, you know, you may be confused, I'm speculating, Your Honor, you may be confused about who did what, but don't worry about Angela Davis. She's having her own trial. And as the record shows, she didn't have a trial.
So I guess my question is, to the extent we're speculating, why didn't the jury apply that same logic to the charges for which they found your client not guilty?
I can't answer that, Your Honor, sorry.
Even if that was the argument, that put aside what charges Angie Davis may face moving forward, how was that vouching?
Well, the prosecutor recited facts not in evidence, first of all. Those facts weren't in evidence. And secondly, she inserted her personal opinion. Her personal opinion was Angela Davis will have her own trial.
How was that vouching?
Well, in the case law, that's what the definition, I saw the definition of vouching to be, inserting your own personal opinion and reciting facts not in evidence.
So can I ask you, when you say it's not in evidence, not to pick up on every little point, but didn't the witness testify that she was subject to 7 indictments related to the abuse, that the case was still pending, that she wasn't made any promises, and that she had no reason to believe that her testimony in your client's case would assist her in her own case? So it seems to me that there was at least some record from which the prosecutor could draw to make an argument that she had a case pending and she's going to trial. I mean,
Yeah,
going
well,
to trial maybe as opposed to a plea or whatever else may have happened is
That's a good
different
point,
story.
Your Honor, and I thought about that for a while. Well, you know, she didn't go to trial. You know, so she didn't go to trial. She, 2 of the 7 counts are no prost, and the 5 other counts, she got probation, 5-year
Right,
probation
so she pled
for.
guilty. So to the extent that she was not fully let off the hook, is that fair? If that's one of the problems, that no one's going to let Angie Davis off the hook. I mean, she ended up pleading guilty, so.
No, I understand your point. I guess I just saw it different. I guess I saw it differently. You know, you're going to,
I'm just trying to understand how the argument that there was no basis in the evidence for this argument at all. That's what I'm trying to understand.
Yeah, well, she didn't go to trial. Well, she didn't go to trial.
Okay.
I mean, just technically,
So
she
that's
didn't
what
go
it
to
is.
trial.
Is the trial part, is that what we're really focused
I
on?
believe so. And, you know, I mean, if you read into that statement, you know, she's going to trial, and, you know, again, maybe I'm reading too much into it. I added, and if she's found guilty, she'll be punished. She'll pay. So, as it turns out, again, this is my interpretation, you know, she pled 2 counts of no prost, and she got 5 years probation. So, where my guy got a lengthy prison sentence. So, you know, maybe I'm just reading too much into it, but that's how I analyze this whole thing.
Sure. Certainly probation is some form of punishment, correct?
Yeah, I agree with you, Your Honor, of course. That's sort of just how I looked at it. Anything else?
Anything additionally?
Thank you.
Thank you.
Thank you. Now hear from the Commonwealth. Attorney Mello.
May it please the Court, Emily Mello on behalf of the Commonwealth. I just want to begin with what the defendant argued in closing, paraphrasing, obviously. He argues that the mom has a motive to lie, that the jury heard about the series of crimes that she's charged with. They heard that she has no plea deal, and he says, so why hasn't her case resolved? She's hoping that you'll convict the defendant so that she can make a presentation in her own case to claim that she's a battered woman and that her conduct is the result of being forced to do so by the abuse of men, and that she should be forgiven for what she has done, that she should not be held accountable for her conduct. Then the prosecutor then responded to that attack on mom's credibility in what I think was an entirely appropriate way. She then said, she began her closing basically by saying, this is true. The mom did do all of these horrible things, and she was charged with those things. And she says, who knows what the defense will be at trial? Certainly suspect it will be battered woman, but that's her trial, and she'll have that because no one is letting her off the hook. The objection...
Is your position that that is completely appropriate and grounded in the evidence, or that at least in some ways maybe it could have been understanding that someone's doing it in the moment? Presumably they didn't write that in if they prepared the closing, that it was better left unsaid or said differently, or you think it's just A-okay?
I would argue, and it would be the Commonwealth's position, that this was an entirely appropriate argument in response to the argument made by the defense. The defense argued that mom had a motive to lie in order to get a benefit in her own case, and the Commonwealth argued that, you know, maybe she is going to try and bring up that defense, but that's sort of not what we're looking at here. What we're looking at here is the conduct of the defendant. And I think that was an entirely appropriate argument to make.
Did Angie Davis admit that she had inflicted horrific injuries on her child, had starved her child, had tortured her child, and had broke her child's spirit? Did she admit to those things?
I don't think she used, broke her spirit necessarily, but I think that, yes, that was the testimony of Angie Davis, was that she burned her daughter, she hit her with a spatula, that she did all of these things, and she testified that I did them because the defendant was standing over my back. And so the argument that the defense is making, which I take the judge's point, at trial, however, I think that battered woman is kind of is a colloquialism in a way. People know what that means. He also explains what that means. He said, well, she wants to say she's a battered woman. She wants to say that her conduct is the result of being forced to do so, which was, in fact, what she said at trial.
So notwithstanding the judge's comments, you would agree that the defense attorney's argument at trial was actually not out of line?
I don't believe that the defense attorney's argument was
You just think both of them were
line.
within the proper lines?
Yeah, I mean, I take the judge's point. I think she was looking at battered woman as kind of like a technical diagnosis term, but I do think that it's something that people understand the same way they understand if someone says anxiety or PTSD, or it's known, and he does explain it, and that was the testimony. The testimony was, I did these horrible things to my daughter, I abused her, and I did it because he was standing over me and because I knew that I was next, that he was going to beat me afterwards. And she did testify but she testified that she did not do anything that would have broken her daughter's bones, etc. Obviously, the jury did not accept that because he was found not guilty of the charge of substantial bodily injury charge, which was the fracture or the injuries to the eyes. So I do think that this argument was completely proper. I think that it was a response to the defendant's argument. It was based in evidence. The only objection that the defendant made at trial was to that verbiage of trial. I don't really see why that's necessarily objectionable. I don't think the judge understood why it was objectionable either. With respect to mentioning the word trial, I would say that's a matter of semantics. The defendant says, why hasn't her case resolved? She doesn't have a plea deal. And that was true. I think what happened in the aftermath as far as how Ms. Davis's case actually resolved hadn't happened yet, first of all. And also, the jury had no knowledge of that. The jury had the knowledge of what was true, that Ms. Davis had 7 indictments pending against her having to do with abusing her child. And some of her testimony was not ideal. She did say, I don't think I should go to jail. She did make these sort of statements. She said, I don't think that I should be punished. And the defense seized on that, and I think that was appropriate, and the Commonwealth replied. And if there are no further questions, I would rest on my brief.
Hearing none, the matter stands submitted. Thank you both very much.
Thank you.
Next matter on our docket is 24P0688, Commonwealth versus Jason Oliver. So I'm going to ask you to pronounce your last name so
Yes.
that I don't butcher it in my effort to do that.
Good morning. May it please the court. Amy Cotignon on behalf of Jason Oliver. Today with me is Attorney David McClellan, who is on brief.
Morning.
I'd like to start today with the protective sweep. I believe that that's the clearest avenue to requiring suppression in this case. And I'm asking that the court focus on what the actual evidence was when the police conducted that protective sweep. Because at the time the police conducted the protective sweep, there was a number of armed officers in the home. Mr. Oliver is downstairs, he's in handcuffs, and that's the reason that the police came to the home that day, was to secure Mr. Oliver.
Just as context, let me ask, are there cases that support a protective sweep after the defendant is in custody?
There are. There are. And there are cases which require that there be reasonable facts, a reasonable belief based on specific and articulable facts that the area could harbor a dangerous individual. So that's what the court needs to find, an area that could harbor a dangerous individual. And the only information that the police had here about who might be in that home is a child. There were 2 children, Mr. Oliver and his wife.
Is there any evidence they knew the age of the child or even the gender of the child?
No. No, Your Honor, there's not. The intel that they had, the only officer that recalls getting briefed on other people being present in the home is Lieutenant Grasso, and he testifies only to 2 children.
So could the child be 17 years old?
The child could. The child could be any age.
Okay.
But that doesn't, the fact that it could be anything doesn't give them specific and articulable facts to believe that a missing child of any age, it could be an infant, or it could be a 17-year-old.
Right. And they're there on a fugitive warrant with concern that there may be firearms and, well, let's say firearms in the home.
So let's talk about that concern, Your Honor, because the concern that there may be firearms in the home, first of all, there's no information as to are the firearms unlawfully possessed. We don't even know if he had an FID card. Are they secured in a safe?
I understand, but the viewing the evidence in the best light for the government, the warrant says there's a person who is the new head of a motorcycle club. His nickname is Guns. The name of the motorcycle club is the Pagans. And I forget exactly what the words were, but there's a good chance that there's going to be guns on the premises.
Right, and for the,
That's the information that the state police had
Right.
when they went to the home.
and for the police to rely on that, it has to
When
be
they went to the
reasonable.
home- When they went to the home at 6 o'clock in the morning. When they arrived at the home, they knocked on the door. You may push back on that, but they knocked on the door, and they saw some movement in the house, but nobody came to the door, right?
Well, that's what they say.
Right.
Multiple
And
people say
that
that's
seems
not what
to-
happened.
That
but-
seems to have been credited by the court.
Yes.
Okay. So they knocked on the door 3 times before they had to knock the door down. So with that as our backdrop, you have the floor.
Yes, Your Honor, thank you. The movement in the window, what they see is a female, who is the first person that they see when they enter at the top of the stairs. And that's Ms. Morales. So that person is accounted for. What they don't testify to is hearing movement upstairs, seeing anybody else upstairs. The people who are downstairs, the police say they told them there was nobody else there. So they have no objective facts to suggest that anybody else is upstairs that may harbor a danger.
At that time, were all 4 people downstairs?
They were not. They were not.
There was just one trip upstairs, if I'm understanding correctly. It's the protective sweep during which the son was found. Is that right? They didn't find him, bring him back down, and then go up.
I'm not clear on that, Your Honor, but I don't know that that's clear in the testimony.
Does it make a difference?
I think it may make a difference if they went upstairs and they bring the one person down and then they go back upstairs and find the firearm. Yes, I think that may make a difference because again, there's no reason to believe that there's anybody upstairs that would harbor a danger to police. And with regard to the firearm evidence, this is what I'd like the court to focus on. In order for the police in Massachusetts to rely upon this email from somebody they've never talked to before, that results from an investigation that they know no facts about, it needs to be reasonable.
Law enforcement agency.
I'm sorry?
From a neighboring law enforcement agency.
Yes.
We're not talking about just some informant off the street. We're talking about a neighboring law enforcement agency.
We are, but there is case law that guides the court's discretion in that regard. And looking at Prevet, which is the recent Supreme Judicial Court case that talks about the collective knowledge doctrine.
I don't see the Commonwealth relying on the collective knowledge doctrine. So.
I agree with Your Honor, but there is a case within that case, which is from the United States Supreme Court, which is United States versus Hensley. The Commonwealth versus Prevet talks about the validity of the intrusion is based on the directing officer's knowledge. And there they cite Hensley, which is a United States Supreme Court case. Hensley deals with a bulletin from police from a neighboring agencies, very similar to what we have here. And that bulletin asks that if somebody finds this person, we believe they're involved in a crime, please stop them, detain them for us, and contact us. The United States Supreme Court indicated that they could detain that person only insofar as to determine whether or not there was a warrant for their arrest, that it did not give them cause to detain them until the other agency came to question them. It didn't give them more than that. And beyond that, the validity of the intrusion depends on the directing officer's knowledge, and that's what's lacking in this case. We do not have any basis of knowledge of the directing officers. So they don't say how they know that he might have guns.
So your position is, it's not exactly this case, but assume for the moment that the directing officer got information from a Rhode Island police officer that we believe this guy has guns. Is it your position that the directing officer has to say, well, can you give me the basis for that? And you can tell me how you know that, and who provided that information for you, when was that provided, et cetera, et cetera?
Yes,
or can they
yes.
just rely on a police officer's information, at least reasonably on some level? Or you think they can't rely at all?
To rely on information from anybody, it requires verification and context, specific facts. So if we knew that this case in Rhode Island, which is a November 2017 single-day conspiracy to distribute indictment, if there was a police report that said, we saw him carrying guns, we saw him wielding a gun, if there was anything in terms of what their basis of knowledge was, then that would potentially support reliance on that. But there's nothing here.
It's your best case that the Massachusetts State Police had to verify the underpinnings of the warrant from Rhode Island. What's your best case for that?
United States versus Henley, which is 469 U.S. 221. There's also a number of other cases, including in the Massachusetts Appeals Court from this court, Commonwealth versus Powell, which is 102 Mass App Court 755 2023, which is reliance on a brick flyer. And there's also a case out of the First Circuit, United States versus Vasquez, 724 F. 3rd 15, which is a 2013 case out of the First Circuit. All of those cases deal with relying on information from other agencies, and it talks about there needs to be reasonable reliance, and it needs to be based upon verification of actual facts, not just statements. And that's what we have here.
Do we know what what charges Mr. Oliver was facing
Yes.
that made him a fugitive? What was that?
It's within the record appendix. It's a conspiracy to distribute indictment for a single date of November 16 to November 17, 2017, so 6 months prior.
A conspiracy to distribute?
I think it's cocaine. The warrant issues the day, May 22, the day before. So it's an investigation that happened 6 months prior. The warrant issues May 22 in Rhode Island. It issues the same day out of, I think, the Framingham District Court, fugitive from justice warrant in Massachusetts.
If, hypothetically, we agreed with you that the protective sweep was invalid, but we thought that the consent was voluntary, as the judge held, or the judge found, what would we do as a disposition?
I would suggest that the actions of seeking the consent are the fruit of the poisonous tree. So at the point in which the police have Mr. Oliver in custody, their job there is done. They do not have any right to remain within that house. They don't have a warrant for it. They have an arrest warrant for Mr. Oliver, and they have no reason to remain. So at that point, anything that happens, if the protective sweep is not justified, which I'm asserting it's not, should be suppressed.
Why can't they ask her for her consent to search at that point?
Well, they didn't. They didn't.
Well, they did, and she refused, and then they went off and got the form, and
But they didn't
she had an
before-
hour and a half to think about it, and she ultimately at least signed the form.
But they didn't before conducting a protective sweep. And they didn't until they had the
Okay,
knowledge
but
gained
what
from
is
the
it,
protective
I'm
sweep.
saying if we decided the protective sweep was invalid, how does that taint the consent search?
I'm suggesting to the court that it's not attenuated enough from the effort to gain. They're in her home still.
Well, just because it happens, just because the consent a search happens after the protective sweep doesn't necessarily establish a causal relationship.
Well, I would suggest that
Well, I'm asking, is there any kind of causal relationship?
there is, because of the timing. So the police conduct an unlawful protective sweep, they come downstairs, they freeze the home, they keep
Do they keep it? What's the evidence that they detain her? I saw that in your brief, and I wasn't able to find anything in the record to support it.
She's detained in the home with I think 12 armed officers. She's not permitted to
But who
leave.
says, she didn't testify.
She did not.
Did anyone say she was detained or that she wasn't free to leave? I don't see that, any evidence of that in the record.
I think it's a fair inference, Your Honor, and I can look back through the
That's a
testimony.
pretty big inference to draw.
Well, her
If
home
that's
is-
the basis of your argument that she was detained.
I don't know that there's any evidence that she was told she could leave.
Well, who's the burden on?
The Commonwealth to justify a warrantless search and seizure. It's on the Commonwealth.
Well, okay, that's a lot of leaps. But other than the fact that the search, pursuant at least to her written consent, came after the protective sweep, is there any causal relationship?
I would suggest that there is, because of the sequence of events which lead to the police seeking consent to search.
Well, sequence of events sounds to me like one thing came after another.
Yes.
I'm asking, is there something else besides one thing coming after another that establishes that there was a causal relationship between the
I'm suggesting
post hoc ergo propter hoc? After this means because of this? That's
so
not
the
enough.
police conduct a protective sweep. They see a firearm, and with that information, they begin to seek consent to search. They didn't seek the consent to search before they went upstairs.
Well, because they thought they wanted to do they did want to do a protective sweep before they get to that. Whether that was justified or not is another question, but
My point is that the police were not lawfully in the home at the time that they asked for consent to search. They were not lawfully there.
how long did
request such consent.
how long elapsed between when they took the defendant away in handcuffs and when they asked her for consent?
I'm not sure that specific timing is in the record in terms
Was that
of when.
relevant? I mean, if it was done at the same moment?
So the police claim that they went in at 6 a.m. The consent to search form is signed at 7:45. They say that it took them an hour to get the form, so I think we can assume that he left at 6:45. That would be my best recitation
Okay,
of what we...
but they asked her for, if they'd asked her for consent at the moment he was leaving,
Yes.
would that have been unlawfully prolonging the, why?
Because he was detained for an unlawful protective sweep. He remained in the house while they did that, while they accomplished that for 45 minutes. He was within custody within 5 minutes. They would have been gone at, say, 6:05. He was in custody immediately,
How do we know that?
based on the testimony of the officers, that he came, that they entered at 6 o'clock. Ms. Morales and her daughter were at the top of the stairs. They yelled to him. He came down. That was the testimony.
If
from
we don't,
there, the
if we
protective
don't
sweep
ascribe malevolent intent, and we just say, for example, why is it not equally likely or equally plausible that, take us, as Justice Sachs asked, take out the protective sweep, and they know that they're going to arrest Guns, the head of the motorcycle club who has 2 kids in the house, and they believe there may be guns there. So after, actual guns, not with the S, not Z. And after they take him out, they're chatting with the girlfriend, and they're sitting around saying, you know, geez, there might be some guns in this house, and we're a little concerned. You don't want the kids to stumble into the guns. Can we search your house and make sure there's no gun here? I mean, I'm not saying that's what happened, but it just seems to me equally plausible. And to the point of whether they shouldn't have been there, again, isn't it at least in some way incumbent upon the defendant or at least the witness to say, well, I asked him to leave, because otherwise they're just there.
Well, yeah, so they asked her for consent to search when they were taking her out, and she did not give it.
Yep.
And they remained there for an hour. And at that point, they had seen a firearm upstairs.
If they'd gone out on the sidewalk, to the front public sidewalk, and waited there until the form had come back with the officer, and then approached the door again and said, we've got this consent to search form, would you sign it? Would that be okay?
So perhaps under the case law, the United States Supreme Court case law, that would be okay. It is my position that the Massachusetts Declaration of Rights should be more protective of people when we're talking about waiver of constitutional rights, that the police shouldn't be able to knock on a door and say, can I search this without cause?
Let me just ask, your red light is blinking, but
Sorry.
voluntariness is a question of fact, right?
Yes.
Okay.
Fact
so
and law.
what is it that I mean, the judge considered a broad range of factors here in deciding that consent was voluntary. Which factor do you think the judge should have considered but didn't, or didn't give sufficient weight to, or gave too much weight to? Because it's a question of fact. If it's not clearly erroneous, then you're stuck with it, right?
It's a question of fact and law, and I think that the presence of the number of police officers, the Supreme Judicial Court has said that that's a factor that can weigh in terms of voluntariness, and I don't think that was given adequate weight. But also the coercive nature of we are going to flip your house upside down testimony. That is inherently coercive for a person who, you know, feels like they have no choice when they're surrounded by armed guards. Her husband was just taken out in custody. She's got children there. She's crying. All of those factors.
There's a case, Commonwealth versus Kip, from this court, 57 Mass Appeals Court 629, where the court talks about a suggestion that if the person doesn't consent to a search, their belongings are going to be disturbed if the police go get a warrant. But nevertheless, the court said that wasn't enough in that case to invalidate the consent.
And I apologize, I don't know the facts.
Because of other factors. So why should it be here?
I think the added issues here. She's taken downstairs at gunpoint. Her children are taken downstairs at gunpoint. There's 12 armed officers in tactical gear. She's in her home, frozen, awaiting a form that she feels like she has no right but to refuse to sign. It's the totality of the circumstances, not just that one factor.
When you say her, I'm sorry, you have something? When you say her children were taken down at gunpoint,
Yes.
are you suggesting that they were all taken down at gunpoint at the same time?
So I think that depends on whose testimony you credit.
Are you suggesting that they were all taken down at the same time?
I think that the judge found no. I think that the judge found the son was taken down subsequent. The daughter and the mother are taken down at the same time. Son is subsequent.
So how reasonable would it be for the police to have some concern about their safety if they believe that there should be 4 occupants in the home, that they have 3 occupants in the kitchen or wherever it is downstairs, and they want to have some conversation with those occupants? should they have to be concerned that, well, there's still a fourth child who could be 17 or whatever age, I don't know. Should we have to be concerned about getting ambushed while we're trying to have this conversation in the kitchen?
So I would say two things to that, Your Honor. The first being, the reason that they're in that home is to execute a warrant. That has been done. They have to
So
leave.
your position is they get the warrant, as soon as he's under arrest, they got to get out the house. Is that your position?
That is my position.
Okay, so
And-
so move on from that.
And then the second part of that question was whether they should be fearful of that child. There's no objective reason that they should be fearful of the child, and that's what
Why
they need.
shouldn't they be? They have a person who is arguably the head of a motorcycle club. His nickname is Guns, and there are guns in the house, and there's supposed to be 4 people, and only 3 are in the kitchen.
So, Your Honor, there's cases in my reply brief that talk about the presence of children in a home, and those cases say the presence of a child in the home is not enough. There's no evidence that there's an unsecured firearm.
In those cases, do they know the age of the children?
In
You're
the,
suggesting that a 17-year-old young man could not have a gun, could not be,
He could be,
could
but
not be a
there's-
danger? Is that what you're suggesting?
no, that's not what I'm suggesting, Your Honor. I'm suggesting that they need to have objective facts of age, and they don't have that here. So he could be 4,
So
he
absent
could be
that,
3.
so absent that, they got to risk it.
No, I'm not asking that they risk it. I'm asking that they have objective facts to enter and sweep somebody's home, to believe that there's somebody that they're harboring a danger. And there's no objective facts here whatsoever.
I think we'll have to leave it there. I understand the argument.
Thank you, Your Honor.
Thank you kindly.
For the remaining issues, I'd rest on my brief.
Do you have something else you want to say?
Yeah, can I just ask
Hold on, I'm
one
sorry.
I actually have one
I'm
question,
sorry.
too. Go ahead. Even though we've gone over, which I hate to
At
do.
the end of the suppression hearing, the
Yes.
third day, which was the argument, defense counsel said he was going to submit a memo. But I don't see that on the docket.
It didn't make it to the docket, Your Honor. It was emailed directly to the court, and it didn't make it to the docket, which is why it's not included
But it
in the record
exists?
appendix. It does exist,
All right.
but it's not filed. It was not filed formally within the
Okay, all
docket,
right.
but it does
Well,
exist.
Could you agree with the Commonwealth on whether that's what you have as a proper copy and then submit it?
I will seek to do so.
Can I ask I hate to, because we've gone way over, but I do have one sort of on a slightly different issue question, which is, unlike a trial and a motion, doesn't a judge have discretion? I mean, whether it ends up favoring one side or the other, whether one side, and in this case, both parties seem to agree, well, we didn't have the right witnesses here, but say all the evidence is closed, and the judge is working through trying to write findings, and they say, geez, I really just don't know where it went on the issue. Can't the judge just discretionarily call everybody back in and say, you know what, I need some more information. Bring in this witness,
So I would suggest,
as opposed to resting like in a trial.
I'm suggesting to the court that it's the Commonwealth's burden to meet their burden of proof. If they don't do it, then that's on them. So it's not up to the court to say this is the evidence that I would need. It's not up to defense counsel to say this is what you need to do. It's up to the Commonwealth to meet their burden of proof on a warrantless search. And if they fail to do so, then that's on the Commonwealth. And that's sort of the argument there.
Okay, thanks.
Thank you.
Thank you. We'll hear from Attorney Nadeau for the government.
Good morning, Your Honors. May it please the Court. Stephen Nadeau on behalf of the Commonwealth. Beginning with the protective sweep, the Commonwealth's position is that the information that the police had prior to arriving at the defendant's residence, in conjunction with the circumstances that they encountered upon execution of the warrant, warranted or justified the protective sweep in this case. The information here, there was testimony to this point. The email corroborates it, was that this was not just, the defendant was not, the single subject of a warrant or the investigation.
Is the email enough? Yes,
I would suggest it
adversary
is
says
in this
it's not
case,
enough.
where it's buttressed by, official supporting documents from Rhode Island. There are clearly charges related to it. These aren't anonymous tips.
What's your best case for the email's enough?
So not cited directly on this issue, but Sawyer, which appears in the Commonwealth's brief and related to the out-of-state warrant issue. There, Maine police relied on a teletype from New York State that there was a warrant. I don't believe they had the actual supporting documentation, but that was enough for them to rely on. Again, I don't think it had quite the same level of factual details here, but the teletype was sufficient that Massachusetts courts held Maine police properly relied upon. Also not appearing in the brief is Commonwealth versus Wilkerson. 486 Mass 159. And at page 170 there, the SJC quotes from Grasso and McAvoy, named informants or concerned citizens are presumed to be reliable and the information they provide credible. And then it's not just that they're named here. Again, there's actual supporting documents, charges had issued from Rhode Island, a warrant had been signed by a Rhode Island judge. So it's not just relying on the information here. Furthermore, again, going back to the fact that this was obviously a Rhode Island investigation that involved a sort of lot of moving parts beyond just this defendant. It was an organized takedown of multiple members in Rhode Island and in Massachusetts. The email, much of it is redacted, but lists, I think, about 6 or 7 total people. The defendant and another individual are the priorities. The defendant because he is apparently the leader of this Massachusetts chapter. So those are all reasons to cause some amount of caution when they approach initially the door. They knock and announce.
The warrant or the arrest warrant is for him being a fugitive. Is that right?
Yes.
Okay. And are the police to take anything from the fact that when they arrive at 6 o'clock in the morning and knock on the door, there's other people in the house, at least a woman, and nobody comes and opens the door?
I think so. So they know that the family at least is going to be there. And perhaps if this is a situation like in Commonwealth versus Sawan, where the defendant or someone presents himself immediately, or even after the second or after the third knock and announce, someone presents, they're cooperative, perhaps you don't get in the protective sweep at that point. But here, they know that there are multiple people in the home. They see an adult woman, notice them, and Trooper Pagliaroni, in page 54 of his testimony, says that the second call and announce was directed directly to her. They saw her, notice them, and they directed their command to come down to the front door with nothing in your hands. And then she went back and they knocked and announced a third time. So I think there the concern starts to ratchet up a little. They're forced to breach entry. And they see initially the mother and daughter. The defendant comes down. There's now someone else that they expect to find there who's not there.
Is it your position, or do you take a position on whether, regardless, let's take it out of the children zone and say the information was just the defendant and his girlfriend lived there, but they do have the information that with the nickname and there may be guns in the house.
Yeah,
that they're entitled to do a quick sweep of the house once they have the people secured before they turn their back and walk out the door so they don't get a bullet in the back, or is it only for people?
I think to sort of
and I'm not suggesting
yes,
they would. I'm just saying, is that a reasonable?
Even if it's just the two of them.
Yeah. And they're both secured. They're down in the kitchen. He's in cuffs, and they're going to, at this point, take him and walk him out the door. Is it your position that before they do that, if they have information that there are likely guns in the home, that they can do a sweep of the house for the guns?
Yes, and I think that's...
What's your best case that says that?
Commonwealth versus Wren is a case like that. I believe the defendant is taken into custody. There are other family members in the home. I think it's his mother-in-law or a co-defendant's mother-in-law that references, his office is in the basement down here. They haven't found a gun, so the defendants and co-defendant are both in custody. They're permitted to do a sweep at that point.
So this is just not, from your position, a child sweep. It's also a where's the gun that might be here sweep?
Yes, and I think that, again, perhaps if there's cooperation at some point, but they face a lack of cooperation, some deceptive answers, and they have information that the defendant's a leader of a gang. He is involved in conspiracy charges. There are likely guns in the house. His alias is guns. Is this a hub for the gang? Could there people be coming in and out, as commonly known with drug trade? Once you start encountering suspicious behavior in fact, I think that does change the analysis, where there is some credible information.
That one seems a bit of a leap, no? That it may be a hub. Where do we get that from? Where do we get that from in the testimony or in the record?
Well, I know that it was Pagliaroni who testified that we were concerned about our safety, and then case law that an ambush in a home where you're not familiar with the layout is more to be feared.
That has nothing to do with whether it's a hub of motorcycle club gun activity.
Sure. But that just goes, again, into the nature of the charges, that he's a leader in the house. They don't have specific information, I believe, that there's drug activity necessarily.
Do you have a position on whether, and again, it's a slightly different situation than what apparently occurred here, but if a Rhode Island police officer picked up the phone and called the person who's leading this warrant execution on the Fugitive Task Force and said, the guy in there, we think he's the new head of the local motorcycle club, and we believe he has guns, that's enough? Or do they have to, is it more of an Aguilar-Spinelli type of analysis where they, while they may say the named and police source is credible, they need to find out about the reliability of the information itself? Or the sort, you get what I'm saying?
I think in this circumstance, perhaps without more, they might need to do a little legwork, but again, it's supported by, again, official documentation of Rhode Island.
In fact, he was charged with a crime.
And they know that, again, this is a more coordinated takedown of multiple people involved in the gang. Again, it's not just dealing with one defendant, one concern.
What is the purpose of telling the Massachusetts State Police or the law enforcement here in Massachusetts that his nickname is Guns, that he may have guns, that he's the new head of a motorcycle club? Why even tell them that information other than we have an arrest warrant for a fugitive?
I think some of that is just to provide context for the officers, and specifically as to the guns, that, hey, just a heads up, you may want to keep an eye out for this. And again, perhaps there's a different calculus if there's at any point cooperation from those involved. But that's not what happened here. There was avoidance and then a deceptive answer, and then in conjunction with what they knew going in, what they encountered, warranted, I think, a reasonable belief that a sweep was necessary. And as to the timing of the sweep relative to when everyone's in custody, it sounds like certainly the defendant's daughter testified that she kind of says everything happened very quickly, including the obtaining of consent. So there's not really any indication of, unduly prolonging this interaction. But notably, they have already found the gun in the bed when the defendant is on his way out of the house, because I believe it's Pagliarone, as he's coming down the stairs, having found the gun, as the defense being let out, asks him, doesn't tell him they found anything, but asks, are there guns or drugs here? And on the way out, he says, I think at first says there's guns, and then tells Grasso on the way out as well that it's specifically upstairs in the bedroom.
I want to ask the same question I asked defense counsel. If hypothetically we decide the protective sweep was invalid, but we think we uphold the judge's finding that consent to the search was voluntary, then what happens to the ruling on the motion to suppress?
I think the consent would have been distinct here because, again, as mentioned, there was no communication to Ms. Morales or to the defendant or to anyone that, in fact, we have found a gun. So as far as she knows, they've done a sweep, found no one, and then is given the opportunity to consent, and initially says no, but then there is some delay in getting this form, but crucially that's not unproductive time for her. They allow her to make calls, sort of weigh her options, and then at the conclusion of that time, once the form is brought back and read to her, she agrees. So again, even if the sweep is held unlawful, it's not like the officer tried to bootstrap what they found from it to, get consent. Not like, oh, we found the gun, we're going to find some other stuff. They kept that from the subject. At least that's my understanding.
So on the issue of consent, in the Kipp case that I mentioned, again, it's 57 Mass Appeals Court 629, the court says, the threat that execution of a search warrant could be very disruptive to the couple's personal belongings was highly improper. Under other circumstances, a prediction of police lawlessness could be sufficiently overbearing to render a consent involuntary. Here, however, the evidence strongly suggests that the defendant's consent, in that case it was the defendant himself who consented, was not motivated by a desire to protect the apartment, and the judge's finding that this consideration didn't cause the defendant to consent was warranted. So in that case, the defendant gave some other reason for consenting that negated the inference that he was responding to the threat, we'll turn your house upside down, or whatever the words were. What is there that's comparable here? What explanation do we have for the girlfriend to consent to the search, other than, it's otherwise we're going to turn your house upside down?
So as distinct here, there's not necessarily an independent basis that appears on the record, but I would note that the officers here did not threaten destruction of the property, just indicated it would be more intrusive if a search pursuant to a warrant. And I cite Commonwealth versus Soto Suazo, where the defendant's girlfriend is asked to consent to a search, and she's told that whatever we find, you will be charged with if we have to get a warrant, and she consents. In that case, consent was altered. I would suggest that is a more coercive line than was put to Ms. Morales in this case. And again, given the totality of the circumstances as the judge found them, was not sufficient to make her consent involuntary.
So what does that mean? Does that mean that if you consent to search, we're just going to give it the kind of once-over look, but if we have to get a warrant, we're going to really search? I'm not sure what that means. Not exactly, but it doesn't contain this same threat of property damage that the Kip case involves. But again, there are, Soto Suazo is not the only one. There are a couple of cases that indicate that kind of statement, standing alone, is not necessarily sufficient to make consent.
It certainly does imply that a consent search is different than a warrant search, which doesn't seem to make a lot of sense. I mean, a search should be whatever you're looking for, you look in the right places and doing it the right way, correct?
Right. And certainly there would be...
So what other inference could one draw if someone's told, well, you can consent and we'll go do our white glove search, or you can not consent, we'll get a warrant and, we bring in the axes and we got the battering ram here already, so let's go.
Sure. And certainly the cases indicate that, there are facts falling on the improper side of that line, and it is just, I think, a factor among all of them to be considered, and I think the judge's conclusion here that it did not convert a consent search into an involuntary consent search was warranted by the record.
Not an enormous issue in this case, and again, as I said, it's especially where it looks like there was a motion filed, then there was an amended motion filed, it was COVID, people didn't seem to have a clear sense of which way they were going and what was at issue. But on the question of what is the judge's discretion and whether and to what extent, because it kind of interests me, once a Commonwealth, if it's their burden, they've rested, they're done, as opposed to the judge being able to say, well, yeah, I need a little more to figure this one out, so let's bring in another witness, or for either side. What's your take on that?
I think, say, we had rested, there were no further evidence of the judge's, not enough, and even if the judge doesn't, ask for more information and he makes findings, hey, the Commonwealth did not meet their burden, I think it would certainly be within our right to ask him to reconsider that, hey, we didn't realize we needed this witness, and it would be within the judge's discretion to allow that.
Open the evidence.
Yes.
On a motion to reconsider, for example.
Yes.
Okay. Anything else?
If there are no other questions, I would just rest on a brief.
Thank you kindly. Very well argued, both sides. Matter stand submitted. Our next matter is Commonwealth versus Edward Lee Davis III, 24P0908. Attorney DeMello.
May it please the court, Your Honors, Kevin DeMello on behalf of Mr. Davis. The search of Mr. Davis' fanny pack in this case was not a mechanical inventory search, but rather an attempt to investigate criminal activity. The investigatory intent of the search made it an unlawful search without probable cause.
So let's just stop for 1 second. So he stops, the officer sees a car that, it's 2 o'clock in the morning, I think, somewhere around that, has 2 occupants in the car. I forget, was there a light out? What drew his first attention to the car?
Headlight.
Correct.
Headlight out. Runs the tags, realizes that the tags don't belong on that vehicle, right? Pulls them over, starting to get some ID. The passenger doesn't have any ID, correct? And the defendant doesn't have the ID either, actually, or proper registration for the vehicle. So the officer says he's going to tow the car, right? Now, when he comes across the fanny pack in the well of the passenger side, doesn't he have to ascertain whether it's the passengers or whether it's the drivers? Because
Yes.
the answer to that question helps direct which way he needs to go next. Is that fair to
Yes.
say? Okay. So he asks, that's a fair question, whose bag is this? So far, so good?
Agreed.
Okay. And so the defendant says, yes, it's my bag, right?
Correct.
So next he says, what's in it? That's where the investigatory piece begins for you?
Well, yes, that is when it clearly begins. But I'd actually back up. When he orders them out of the car, he asks them, is there anything on your person? That's already signaling an investigatory intent here.
Well, he asked him, any weapons I should be aware of? He's one officer, it's 2 o'clock in the morning with 2 guys. I mean, shouldn't he be concerned for his safety?
Well, there's no indication in the record. First of all, the Commonwealth didn't argue that. I don't think there's any other facts in the record that suggest that he should be concerned about weapons.
Simply 2 guys in a car at 2 o'clock in the morning and he's by himself and they don't have ID and they've got the wrong tags on a car. He can't ask, are there any weapons I should be aware of?
Well, he can ask,
Okay, so he did.
but I think that speaks to the officer's intent. I think at that
Why does
moment,
the intent matter? The inventory policy says, I mean, you don't contest that the car was lawfully towed, right?
no, Your Honor.
Okay. So the inventory policy says, all closed but unlocked containers shall be opened and each article inventoried individually. So what was, I mean, didn't the officer, if he had followed this policy, have a right, and in fact an obligation, to open that fanny pack?
I think he had an obligation to open anything that was going to remain with the car. And I think the problem here is he asks what's in it before he ascertains, is this going to be left with the car?
Okay, so well, it was sitting on the floor of the car. The defendant didn't take the fanny pack out with him. So does the officer have to say, do you want to take this with you, or shall I search it?
I think
part
in
of
the
the inventory
circumstances of this case, he's got to at least allow them an opportunity to take things out of the car, because he's not allowed to search things that aren't going to be left in the car. And I'd also point out, I'm not sure if Your Honor's had the chance to watch the video.
We did.
When they look through the video, his wallet's in this bag. I don't think it's reasonable to conclude that he was going to leave this thing in the car if his wallet's in it.
Okay, but the officer didn't know his wallet was in the bag. He didn't take it with him when he got out of the car.
Correct,
For all
but-
the officer knows, that's something that somebody else left in the car. Defendant doesn't know whose fanny pack it is or what's in it. Why does the officer have an affirmative obligation to say, do you want to take this with you?
I think in the circumstances of this case, he does. He's got to determine what's going to be left in the car, and this is a passenger. He knows that it belongs to the passenger before he starts to ask what's in it. The passenger has nothing to do with why this car was pulled over. He's a totally innocent bystander. The officer has no reason to suspect this passenger of anything other than not wearing a seatbelt.
So when the officer says, who does this belong to, if both the defendant and the driver had said, we don't know, then the officer should have left it in the car, right?
Absolutely.
Okay, and would have been authorized and in fact required to search it.
Correct.
Okay, so once the defendant says, it's mine, then what does the officer have to do, in your view?
I think the officer either has to say, I'm going to impound this car, do you guys want to take anything out of it? Or, in this case, when he finds out it's the passenger's bag, he said, hey, is this going to stay with the car, or are you going to take this with you? I don't think that's an unreasonable thing to ask of a police officer. I don't think, in the context of this search policy, I don't think it's an unreasonable thing.
It might not be unreasonable to require the police to ask, okay, what are you going to take with you before we do our inventory search? But it's certainly not what the inventory policy requires. I'm not sure there's a case that requires that. So are we to recognize a new requirement for inventory searches that the police say to the subject, we're going to search your car, and here are all the things we need to do as part of an inventory search. So before we do that, do you want to take anything out of it?
Right, so I think so, Your Honor. I think, first of all, when you look at the inventory policy, it does say that the officer can allow them to take items if there's not probable cause. So there's at least something there. It doesn't say affirmatively the officer has to ask. But I would point to the Abdullah case that I sent a 16L on. In that case, the police searched a bag that, it's a slightly different case, I understand, Your Honor. But in a case like this, in these limited circumstances where it's a passenger, he finds out the bag doesn't belong to the driver, he never bothers to ascertain whether this is going to stay with the car or not.
So can I ask you, so they are, one of the reasons for the inventory policy is to protect the police from unwarranted or false claims that you took my stuff, for you, right?
Right.
Fair enough. And so you're allowed to inventory whatever items, and that would include before you give the item presumably back to the person who's going to walk away with it. In this case, walk away. Sometimes they're under arrest and you give it to a third party.
Right?
Right?
No, I don't think that's the requirement in this case. I think the issue is when they impound the car, the car...
Was the car impounded at that point? When they say we're going to tow the car and I'm going through it to inventory its contents? Doesn't it already have to be impounded at that moment? Not that physically brought to the police station. It's impounded for all intents and purposes, right?
So the purpose of the inventory search,
Right.
like you said, is to protect the police from, and the public
Right.
from things that are left
Both
in
ways.
the car.
Okay.
And if
So-
this thing isn't going to be left in the car, the inventory search isn't going to be accurate if he inventories what's in it.
So if he's handing the guy the stereo, like in Niccolo, handing the grandmother the stereo, right? We know what a stereo is. Here's your stereo. Okay, there might be, maybe they unscrewed and stuck some stuff in there, but not likely. If you're handing someone a bag, a backpack, like this, right? What if there's $5,000 in there? We know his wallet's in there. How does the officer know that the guy's not going to say, well, geez, when I made me get out of the car, I had $5,000 in my wallet sitting in that bag, and then I walked home and I opened it up, and there's a wallet with just my IDs in it. Where's my $5,000? How does he protect himself from that claim?
Well, that's the Abdullah case. The Abdullah case,
It's a
the
little different from
officer
Abdullah.
handed over a bag. And the court said it wasn't appropriate for them to search the bag before they handed it over.
So would it have been at least reasonable, and putting aside whether we agree or disagree or where we think Abdullah falls here, would it at least have been reasonable, which is the touchstone, for the officer to say, while on body-worn camera, hey, well, what's in the bag? So that way, if the guy says, nothing, just some clothes and I got some IDs in there, okay, great. And then when he later says, and my $5,000, you say, well, you didn't say that at the time. Or, is that unreasonable to at least say, well, before I hand it back to you, I'm not going to go into it, but at least tell me what's in it?
I don't think it is, and you make a good point.
All right.
This is on
So,
body. This is
okay.
on body camera.
So assume for the moment it's not unreasonable for the officer to say...
I'm sorry, I misspoke. I don't think it's reasonable for the judge, for the officer to ask what's in the bag because this whole thing's on body camera.
Well, inside of the bag is not on body camera, right? What's
No.
inside the bag is not until he opens it.
No, but how can he be accused of taking something out of the bag if everything he does is on body camera?
So take the body camera out of it then. Just take the body camera out then. This one it happens to be. And the question is, what is reasonable and unreasonable? Is it reasonable?
I think, honestly, Judge, I think it's a hard case. And I think this might be a very specific case, maybe even a one-off case where in these limited circumstances, this search wasn't justified, but maybe this isn't a big rule that we want to apply everywhere. I don't know.
Before we get,
sorry.
yeah,
Go
I'm
ahead.
sorry.
No,
Before we get to whether the search was justified, because arguably he had consent to search. So before we get to whether the search was justified, we need to determine, I think, whether or not the question was justified what's in the bag. So we've got to the point where whose bag is it? The passenger says it's my bag. So at that point, now what happens next? I think that's where at one point we got that far. And so the idea is, if it's the passengers, that he's going to give it to the passenger, correct?
Correct.
Right. And so he says, what's in it? Now, is that a fair question? Should an officer who's on the side of the road by himself with two occupants, with maybe a little bit of heightened suspicion, given the tags don't belong on the car and they don't have any ID, should he be concerned for his safety?
I think the answer is no, and I think that's the Torres case. In the Torres case, the officer pulled someone over for speeding, asked for what's in his pocket. And that right there is when the judge said, or the court said, that transformed it into...
That's different because you're pulling somebody over for speeding. You're not having anybody on the side of the road. You're not waiting to have the car towed, at least so far. Here, we have two guys on the side of the road. I'm going to be waiting here by myself, waiting for the tow to come. Arguably, if he had just handed the guy back the bag, the guy would have had the gun, correct?
Correct.
So my question is it fair for them to have any safety concern? Is it fair for any officer to have any safety concern when they're by themselves and they stop a car at 2 o'clock in the morning that has multiple occupants?
So I think this goes to the Terry Frisk type of situation or a protective sweep type of situation. And in those line of cases, they say the officer needs to have specific and articulable facts that there is some danger to the officer. And I don't think we have that here.
And I'm asking two guys, 2 in the morning, long tags on the car and no ID. Is that not specific, articulable facts
I don't think
to
it's
give the
enough,
officer
Judge.
pause?
I don't think it's enough, and if you give me an opportunity, I'll find a case that I think says that.
I'm sure you will. I'm just asking.
I don't think it's enough, Judge.
So in the Niccolo case, footnote 4 describes the inventory policy that was in effect at the time of the case. And it says the policy required police to ask the owner of the property in a vehicle for his preference as to its disposition.
Correct.
So the policy was revised in 2021, or at least there is a 2021 version in the record here that is the governing version, and it doesn't say that. It says if the owner asks, not the police must ask.
Correct.
So if the policy, I mean, Abdullah and Niccolo are good cases for you, obviously, but the inventory policy appears to have changed, or at least to be different from what it was in Niccolo.
What I would say is that the inventory search can't give the officer reasonable suspicion to ask investigatory questions.
Shouldn't it not give them discretion? Because I think that's the problem here, and I think maybe that's why they changed the policy, is to take out the discretion, which is the whole point of the administrative search, right?
Well, I think there's a problem with
I'm going to ask you, do you want to take it back? But this person, I'm not going to ask them if they want to take it. This one, I'm going to wait for them to ask. It just seems to me that you got to give them pretty firm, strict rules here.
Honestly, that's probably why the policy should say you need to give them an opportunity to take stuff out of the car if you're not going to detain them. That would be the clearer and better approach.
Are you suggesting he didn't have an opportunity to take it out of the car?
He did not have an
Well, I mean,
opportunity
when
to take it out of the car in this case.
When he got out of the car?
The officer ordered them out of the car,
Yep.
and I don't think it's reasonable to assume that if you're ordered out of a car by a police
grab your
officer,
wallet?
that you're going to gather up all your stuff and take it with you.
Okay. But he didn't have an opportunity to reach down and grab his fanny pack with his wallet in it?
I think in the context of this case,
That's fair. That's really not a side issue then.
So
you
was
know,
it
I don't think
improper-
that's something a reasonable person would do, being confronted with a
So it
police
was an
officer.
improper question. What if he had said, hey, what's in the bag? And the defendant said, my personal belongings. No search, right? Would that, is there an impropriety there?
I'm not sure I understand the question.
So here, he asked the defendant, what's in the bag? And the defendant doesn't answer him. He says, you can look in it. And so he does. So the only thing he did wrong, as I understand your argument, was ask him what's in the bag. Or do you say there was something else that he did wrong?
I mean, I think that's true, but I think it's also important to look at the total context here, that you have two kids of color being pulled over by a white police officer. As soon as he orders them out of the car, he says, is there anything on your person? He finds this bag. Hey, what's in the bag? This is why I cite Ortiz. Arguably, this is a pretext. It's not a pretextual stop in the sense that they had a reason to stop, but like this is an officer who's like, hey, it's 2 o'clock in the morning. Given the circumstances, I'm going to look into this a little bit, and that's prohibited. That's investigative.
Can I ask one, I know we're over time again, one quick question on the other issue, which is on the witness. The SJC heard Collins versus Smith on March 3rd, which seems to me to be the exact issue.
Yes.
Do you have any thoughts as to what we ought to do with this particular issue at this point?
Well,
Other
the
than
only
wait and see
thing
what the SJC says, because
the only thing I would say is my client's still in custody. I wouldn't want to delay the decision on this case if that. But I also understand.
I mean, you agree that it's the exact issue?
It's the exact issue, and I can't really speak to it here. I mean, the SJC is going to decide it. So,
Okay.
Any other questions? Then I would just close by saying that, this isn't a case of a kid who's involved in gang or violence or crime. This is just a kid who made a mistake. He's got no criminal record.
Is that in the record? Or are we talking outside the record now?
It's out. Much of that is outside the record, Your Honor.
That's your time.
I will rest on my brief. Thank you.
Attorney for the Commonwealth.
Hey, good morning, Your Honors. If it pleases the court, Adam Azonson for the Commonwealth. I have to pronounce my last name. So we have some issues to talk about, and I think first.
Let's begin with, does he have a right to ask him what's in the bag?
Yes, at 2 o'clock in the morning, pursuant to an inventory search and a garden variety traffic stop with reasonable safety concerns, I think.
Best case for that?
Best case to ask what's in it?
Best case for that proposition that you just told me?
I don't have one, Your Honor. With me.
Isn't inventory, just so we're clear on this, inventory and reasonable fear, based on some articulable suspicion, are two very distinct concepts, right?
Yes. Well,
so the 2 a.m. really has zero to do with inventory. Is
correct.
That fair?
Well, the
2 a.m., two guys out in the middle of nowhere. Well, Pittsburgh's not middle of nowhere, but
yeah, it was a garden variety traffic stop, and because didn't have a headlight, and the person
just stick with me. Just stick with me for a moment on the issue. Right. So, 2 a.m. The number of people, whether it's 10 of them and one of him, does that have anything to do at all with the inventory policy and how you conduct an inventory, an administrative inventory?
I don't believe the inventory search would be affected by that as a mechanical administrative.
Issue about whether they are reasonably in fear is a completely separate issue.
I think it would go to the argument of the defendant's argument of probable cause, whether there was probable cause at that point, at that hour, and at that point, whether when you're
stick with the inventory for a moment. Just stick with the inventory side of the inventory. Let's stick with the inventory side.
A safety concern could arise.
Hang on. To Justice Desmond's question, under the inventory umbrella, is there anything wrong, or is there everything right, or somewhere in between with saying, hey, what's in the bag, before you hand it back to the person who's going to take it away?
I don't believe there's anything wrong with asking it.
And do you have any case that says that they can? Does the inventory policy say you can ask what's in the bag before you hand it back?
Yeah, the inventory policy requires that they do the inventory search, and it requires that they open unlocked containers that they come across. This was an unlocked container that he came across, and again, I do want to kind of go back. At 2 in the morning, I think it's reasonable to ask what's in the bag when you're doing an inventory search, because as you're placing your hand, especially after they consented to the inventory search, you may prick yourself with a needle, or there could be drugs in the bag. So you should know what's in the bag that you're about to inventory.
But you're not going to inventory the bag if it's the passenger's bag, right?
Mm-hmm. That's not clear to me.
You're going to give it to him.
It's not clear to me that it's a requirement to hand over unasked for items that are left. It was left in the automobile, and the automobile was impounded at that point, and the inventory policy requires.
And what difference does it make who owns it?
Who owns the bag or the
property in the car? What difference does it make? If you're going to inventory it anyhow, then why even ask, is it yours?
I think in the context of the stop itself, where the owner of the car was already out of the car, and the defendant, the passenger, was still inside the car with the bag.
But he wasn't. He was out of the car, too. He was on the side of the
Well, he was then asked to leave, but he was remaining in the car with the bag at the time. So there was a
time of what?
At the time that the officer was checking with CGIS the registration and license information.
Yeah, fine, whatever. At that point, when he asks him whose bag is it, they're both out of the car.
Yes.
So why are you asking him?
I think as part of the traffic stop, and in conducting, I mean, again, you asked, is it part of it? But I would think that the inventory policy doesn't say, you know, ask this, ask that. It just says if they ask you, you may give this over to them. But I think in the context of being 2 in the morning and performing an inventory search, which the policy says it's best to do it on the scene at 2 in the morning, you have a bag that you don't know whose it is, and if it's the passenger's, maybe that changes it. It doesn't mean that you need to give it back to them, but it would be good to find out who it is so you can ask that person what's in the bag.
Excuse me one second. What if the inventory policy is not consistent with the law?
Well,
What do you do with that?
I think that's a question for...
Well, my question is this inventory policy, which, as
Yes.
Judge Sachs pointed out, seems to have changed from the older one, why do they change it? Is there a case that says what they say it now, what the policy now says, that essentially the onus is on the property owner to say, I would like to take that with me, as opposed to the police to say, would you like to take this?
Yeah, I don't have context for the reasoning why they made that change to it. I'm sorry.
Let me ask you a different question then.
Yes.
How's this? So let's flip over to the other side of the line here, to the, it's reasonable before the officers at 2:30 in the morning, given all the circumstances here, it's reasonable for them to at least the officer to look in the bag before he's handing it back to this guy, 2-on-1, middle of the night, all that. All right? Is that your position?
The position is that the bag was left in the car,
Yep.
and it has to be inventoried according to the tow policy.
Okay,
and the
so again, that
inventory
has
policy.
nothing to do with whether they're reasonably in fear or it's 2 in the morning or there's 2 of them and 1 of him, right?
I mean, in conducting the search, those things will come into play, and it's just a reasonable question in conducting the inventories. It's not required by the inventory search, but in doing, if the inventory search was done at 2 in the afternoon, maybe it would have been different. Like, it's 2 o'clock in the evening, and you're asking them
It just seems like you're conflating them. So you're not suggesting then, that the police had an independent basis, given the fact that the police officer had an independent basis, given the fact that, again, it's, 2:45 in the morning by the time he's doing it. He's by himself. There's 2 of them. There's some issue with the plate. Looks like it's attached, wrong car, all that. That before I take a bag and hand it back to you, I at least have, as a police officer, the right to look in and make sure I'm not going to get shot by the gun. Do you think that he has the right to do that?
I believe he has a right
All
to
right,
ask.
well, let's say then we change the situation and the defendant got out of the car and he had his fanny pack on him. Could they have patted him down as a protective frisk,
Well, I mean, that's
based on the facts of this case?
I think there may have to be more, but at 2 o'clock in the morning, an officer does not have to gamble with their safety.
So, okay, that's a great point, and I tend to agree with you in the general principle, but if he's wearing the bag and you can't pat it down even,
Right.
to see if there's something in there that's dangerous, and you can't pat him down to make sure he's got something on him that's dangerous, because there's nothing to suggest so far in this case that either of these men posed a danger, reasonable danger to the police officer or to the public, right?
Yes.
Fair?
Well,
And how do you use that as a justification to open the bag and look in it before you hand it to him?
Well, I mean, a pat frisk is qualitatively different than what goes on in an inventory search, and the purpose of the inventory search is an administrative mechanical thing, and all the officer is doing is checking his safety before he sticks his hand into a bag that he's required to search. If he was outside of the car and he had the bag, it'd be different. You might have to, look, were there furtive movements? Was there this? Was there that? But even that, I'm not prepared to argue that. I'll try.
Okay, no, it's okay.
Yeah.
Was the defendant free to leave?
The defendant was never told that he was not
Was he
free
free
to
to
leave.
leave?
Yes. I mean, it was 2:30 in the morning, and as it was mentioned, where was he going to go? It was, on Route 12, and
I
he
don't
spent
know. I'm
his
just
time.
asking, was he free to leave,
free
or
to leave.
did he have to stay there while the officer was doing whatever he was doing?
He was free to leave. He was never told that he was never detained. Detained in the sense that it would require probable cause for a search.
As Niccolo defines an item, in other words, that the police, before they use the term, the court used the term item, you did, right?
What was that?
Item, what is,
Item.
before you
Yep.
look at an item, what do you construe an item to be? Is it the bag unit, or is the item what's inside the bag? Are they two different things? What is it?
Well, I don't know. I mean, the Niccolo case and the Abdullah case are, I mean, I guess they're related. They weren't raised at trial, and they weren't raised in the brief, and I don't know that we want to take those and bring it into here, as they weren't really the subject of
I guess
the
my question
analysis.
is, when we say items of personal property,
Yep.
that can be inventoried, is the item just the bag? I see the bag, that's a unit, or because it's unlocked, the item then consists of that bag and whatever's inside, you need to catalog that before you give it.
Correct. The inventory policy, in our case, TRF 10 requires opening the bag and inventory, individual policies for the reasons that you stated, to protect against theft and claims against that. I mean, Abdullah is slightly different. It's not a motor vehicle case either, and they gave some of the property in the bag here, and they didn't some of it here, and in Niccolo, they gave some of the property to the grandmother, and they retained the bag to search later, and what they ultimately decided in those cases is that, there was too much discretion. They were using too much discretion, and that's what we don't want to have happening during these searches. We don't want the police officers going beyond the mechanical administrative part of this search to take the items, catalog it for those three reasons. And while they're doing that, they're allowed to maybe keep their personal safety. At 2 o'clock in the morning, like to what you were saying, I think it's reasonable.
It seems that Counsel DeMello takes issue with the fact that the officer asked, whose bag is it? And so, what's the point in asking that question? And do you think that that's an improper question, and if not, why?
Well, I think asking whose bag it was may just been the pretext to ask what's in the bag, to make sure you're asking the right person, what's in the bag. I mean, I can't speculate as to why the officer was asking what was in the bag, except that it was part of the inventory search. He's started the inventory search. It actually started. He was doing it in the car. He came across the bag, and now it's time. He sees that the bag was in the area where the defendant was, so it would make sense. Let's ask, is it yours? Because if he says no, then he probably is going to be asked the other guy, is it yours? And then the next question is going to be, what's in the bag? Because I have to inventory.
Why is the next question not, are you going to take this with you or leave it in the car?
Because that's not a required question. It's a may question. It's an if question. If the defendant had asked for it back,
Okay. That's according to the policy.
That's according to the policy.
And what statutory or case law authority is there to say that that's the right next question, the proper next question?
I don't think that there is a case that addresses an officer asking what's in the bag and then what the next question is. I think it's just in the context of an inventory search. When you're about to do an inventory search and you find out whose bag it is and you're doing an inventory search, the next logical question while you're searching into it might be what's in it. Anything bad? Anything that could be harmful to me? And at that point, I'll just raise as well. I mean, again, maybe it's not the right issue, but the defendant consented, said, go ahead, look in it, open it up. So then the police officer did, and that's where he found a firearm.
Can a police officer approach someone on the street who's carrying a fanny pack and say, what's in the fanny pack?
A police officer can probably ask a question, but I don't know that requires that the defendant answer it, and I don't know that would require that the defendant, I mean, context might be important, but I don't think that defendant would feel that he was couldn't be free to leave.
If the officer has no reasonable suspicion that any contraband or anything dangerous is in the fanny pack? Can the officer approach the person on the street and say, what's in the fanny pack?
Like a Terry stop? I mean,
No, I'm not sure it is a Terry stop.
yeah, I don't,
I'm just talking about a question.
okay. I think a police officer can come up and ask whatever questions that they would like to a person, as long as the person doesn't feel that they're required to answer it, or that they are, you can't stop someone and pat them down and start searching, but to just ask a question, you can ask a question, I think.
So if Mr. Davis had here and said, when asked, what's in it? None of your business, or I don't know, or I'm not telling you, what's the appropriate response at that point? What could the police officer have done? What should the police officer have done?
I mean, I still think at that point it would have been proper for the police officer to have opened the bag and searched the bag pursuant to the inventory policy that he had.
And if the defendant at that point had said, it's none of your business, that's my bag, I want to take it with me,
Okay.
then what?
Well, now you have a timing issue, because I think that if he had asked when he was leaving the car or at any time before that, then maybe. But once the inventory search has started, there's no reason to have him stop the inventory search. And when you find
do the defendants know that that's what's happening? I mean, he didn't say, hey, I'm now going to do an inventory search, right? He didn't announce I'm doing an inventory search. He tells them, get out of the car, and he's going through the car. He doesn't tell them what he's doing. Are they supposed to be alert? Wait a minute. He's now told me he's going to do the inventory search, so now I can tell him, hey, that's my bag. I don't want you to inventory it. I'm taking it with me.
Yeah, I don't imagine that a defendant would be extremely familiar with the police inventory or towing policies, but they are the policies, and the police are aware of them, and they are required to follow them. And in this case, that's exactly what he did.
Is it clear from the video that's what he's doing, that he's doing an inventory search? Would you say that's clear from the video?
In my mind, it is.
When
Per
he's
the
thumbing through
policy.
the wallet, maybe when he's thumbing through the wallet and pulling out IDs?
It's all part of the inventory search?
That wasn't raised in
No.
I don't know that you need to, I think if you're investigating, that would certainly be improper. If you're investigating a crime, which there was no alleged crime being here beyond the
If you're investigating a crime, it's improper to look in the wallet, but if you're just doing an inventory search, it's okay to look in the wallet.
I don't know the answer, whether, I don't know that you can go through a wallet as part of it, unless there are items that are in the wallet that need to be inventoried that could be claimed to be
Certainly want to
stolen
inventory
later.
whether there was a lot of cash in there.
Correct.
Or whether there was no cash in there.
Yep. If there was $1,000 of cash in the wallet, that would be good to inventory, I would imagine. So, if there are no further questions,
Hearing none, the matter stands submitted.
thank you very much.
Thank you very much.
Thank you.
Take a brief recess.
Court all rise.